So we said the first question that a court must ask is, does the non-competition agreement serve a legitimate business purpose? And we refer to that as the threshold question, because if the answer is no, then you can stop your analysis of the non-competition agreement. And so on your test, when you're trying to decide, is this a valid non-competition agreement, if in fact it doesn't meet one of those first two standards, then it's not going to be justifiable. It's not going to be enforceable. The second question is the non-compete agreement restricted? Restricted. And what do we mean by restricted? To be enforceable, the non-competition agreement must be limited in some way. And we refer to these as restrictions. And the first of these is restricted by time. So for every non-competition agreement, every enforceable non-competition agreement, there must be some restriction as to the time. And if that restriction is missing, then it's not enforceable. If it's there, we have to make the decision of, is this a reasonable restriction? Is this a reasonable restriction? And the idea is the time limit should go no more than what is necessary to protect the interest of the business, the legitimate business purpose that the business had for entering into the non-competition agreement. So the fact is, this can change. Now realistically, anything 6 months or less is probably going to be considered reasonable. However, where you get into issues is how much beyond 6 months. A year, depending on the type of work, depending on the type of knowledge that the person may have. 2 years, sometimes for sure. If you are involved, say, in oil field sales, and you know that most parts of a oil refinery or operation, they're only purchased once every 5-10 years, then maybe a 2-year restriction is okay. Much beyond 2 years, I think you need some special justification for. So if you were a member of the top management team, which presumably gave you access not just to things like price list or trade secrets, but also extended to future expansion plans, you have a bigger, broader view of the company, then your restriction could be more than, say, an engineer who only works on one particular aspect of a job. You have to take into account the type of job it is in order to determine whether something is reasonable or not. So if you're in the technology field, you know, if your specialty is working on mobile telephone technology, well, obviously, if you look back over the last 10 years, that's been a rapidly evolving area. And so anything that you know is likely to be much less important a year from now. And by 2 years, no one wants that knowledge that you had anymore. So for a position in a technology field, it may be a compressed time period. It may be 6 months or a year. It would be reasonable. So there's no hard answer. There's no defined answer. That sometimes even 6 months could be seen as being too long if it was a lower skilled position, like making sandwiches. Jimmy John's was famous, or infamous, I guess, for requiring its sandwich makers to sign non-competition agreements, but prevented them from working for another sandwich company for 6 months. And so many people thought that was not reasonable. But if you're a CEO, 5 years may be reasonable. So there's no hard line that you can decide 2 years acceptable, 3 years unacceptable. You just have to be able to analyze the type of job and be able to argue why this time period is proper. And again, when it comes time to work on your writing assignment, one of the things I'm going to ask you to do is to make restrictions and then justify the restrictions that you have created. The second restriction is geographic location. And honestly, this restriction is probably less important than it was originally. When the law was created about restricting non-competition agreements, there was the belief that we need to protect people's home area. If we have a salesman who works in certain zip codes in Houston, Texas, then it's okay for that salesman to go work elsewhere because they're not going to compete against their former employer. But if they go into business and they're servicing those same zip codes, then that looks like unfair competition. So if I work in a 3-state area of Texas, Oklahoma, and Louisiana, for instance, when executing a non-competition agreement, it may be quite likely that I am restricted from working in those 3 areas. Now, I may be able to go work over in California or Alaska immediately, but I could be prohibited from working in one of those 3 states for some time period. Now, of course, the problem with this idea, which made so much sense that, if you are working in a geographic area, that's where your business base is, that's where your customers live, that's where your work takes place. Well, now in the age of the internet and globalization, your business area, your market area that you affect could be not just statewide, but countrywide, and in fact, in some cases, worldwide. So again, there's no hard and fast rule. You look at the job, you look where the customers are for that job, where's the work taking place, and then you try to restrict it by that area. And if in fact you are a global company that sells products around the world, you may be able to qualify for a geographic restriction of the whole world. Now, courts don't like to see that. They want to see it much more restricted. But nevertheless, in the modern age, we are aware of the broad capabilities of employers to do work. The final restriction, I call it scope. It means the scope of work, the type of work. If you are an engineer working for a company and you change jobs to go work for a competitor, and maybe in the next position you work in advertising, it's quite likely that whatever you knew as an engineer is not going to give you an unfair advantage as an advertiser. So therefore, when we execute our non-competition agreement, I must restrict it by the type of work that you are doing. And if you're an engineer, then I say you can't do engineering work for these particular competitors for this particular time and in this geographic area. So scope of work. If you are a janitor at one place and you get hired as a salesperson at another place, again, probably not going to be able to restrict you from that second job. They may be able to restrict you from moving from one sales position with a firm to another sales position at another firm. So restricted by scope. So when you do your analysis of a non-competition agreement, you start with that threshold question, is there a legitimate business purpose? If you decide yes, then you move to the next question, is it restricted? Are the restrictions reasonable? And there must be these 3 restrictions, and they must be reasonable. Reasonable is a gray area. You have to justify it in terms of the type of job and the type of work that is taking place, and then be able to craft a non-competition agreement that doesn't extend beyond those ideas.